Warm greetings everyone. I hope you are doing fine. I'm Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In the present module, we will learn about the dissolution of marriage under the Special Marriage Act 1954. My dear learners, the learning outcomes of the present module will be, first of all, the overview of the topic, then the FoL grounds for divorce. Also, additional grounds of divorce available exclusively to wife. Alternative relief in divorce proceedings. Divorce by mutual consent and then irretrievable breakdown of marriage. And finally, the conclusion. Now, let's begin with a brief overview. As discussed in the previous modules, the Special Marriage Act 1954 is applicable to all Indian citizens of all faiths such as Hindus, Sikhs and Muslims, along with Jains, Christians and Buddhists, even non-resident Indians. Through this act, legal recognition of marriage is ensured as one can register their marriage, which further provides various legal benefits to the couple, including succession rights, social security benefits and inheritance rights. Moreover, the Special Marriage Act is different from personal laws as it enables marriage between intercaste couples without converting the religion of the other before marriage. Divorce means the dissolution of marriage by a competent court. Divorce arises when a person wants to break an onerous marital relationship. The law provides for a way to move out of an unpleasant marriage by seeking divorce in a court of law. Under the Special Marriage Act, the three theories of divorce, that is, fault theory, mutual consent theory and irretrievable breakdown theory of divorce are recognized, and divorce can be obtained on the basis of any of them. Dear learners, let's discuss the fault grounds for divorce. The fault theory of divorce is also known as the offense theory or guilt theory. Therefore, it highlights the point that a marriage can be dissolved when any of the parties within the bond of matrimonial ties commits an offense against the innocent party of the marriage. Thus, it is necessary to have a guilty partner and an innocent partner within the bond of matrimonial ties. The innocent party only has the right to seek a remedy for the divorce. FoL grounds for divorce are provided under Section 27 of the Special Marriage Act. These grounds are: number 1, adultery. If either of the spouses intentionally engages in sexual relations with another person after marriage, the other spouse may seek divorce on the grounds of adultery. Divorce on the grounds of adultery is based on the principle that marriage gives an assurance that the spouses are sincere and honest towards each other and towards their matrimonial relationship. Adultery, earlier an offense under Section 497 of the Indian Penal Code, has now been decriminalized by the Supreme Court of India in the historic decision of Joseph Shines versus Union of India in 2019, on the ground that subjecting interpersonal relationships to the severity of criminal law would amount to an intrusion into the right to privacy guaranteed under Article 21 of the Indian Constitution. Section 497 of the Indian Penal Code provides that whoever has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man, without the consent or connivance of that man. Such sexual intercourse not amounting to the offence of rape is guilty of the offence of adultery and shall be punished with imprisonment of either description for a term which may extend to 5 years, or with a fine, or with both. In such a case, the wife shall not be punishable as an abettor. Thus, adultery refers to voluntary sexual intercourse by a man with the wife of someone else. It is pertinent to note that adultery as a fault ground for divorce is available under various personal laws as well as under the Special Marriage Act. Adultery by its very nature is a secret act. Direct evidence of an act of adultery is extremely difficult, but the evidence of adultery, whether direct or circumstantial, must be necessarily of such a character as would make a reasonable man believe beyond any doubt and a mere probability that adultery may have been committed is not enough. In the case of Dastane versus Dastane, 1975, the Supreme Court held that there is no necessity of the presence of proof beyond reasonable doubt, where personal relationships are involved, especially those between a husband and wife. Next ground is desertion. Now, desertion means the intentional, permanent forsaking and abandonment of one's spouse by the other without the other's consent and without reasonable cause. It is a total repudiation of the obligations of marriage. In view of the large variety of circumstances and modes of life involved, the court has discouraged attempts at defining desertion, there being no general principle applicable to all cases. In Lashman versus Meena, 1964, it was held that the legal burden is upon the petitioning spouse to establish by convincing evidence beyond any reasonable doubt that the respondent abandoned him or her without reasonable cause. The petitioner must also prove that there was desertion throughout the statutory period and that there was no bona fide attempt on the respondent's part to return to the matrimonial home, and that the petitioner did not prevent the other spouse by his or her action, by word or conduct, from cohabitation. The offence of desertion commences when the fact of separation and the animus decidendi, that is, the guilty intention, coexist. In Bipin Chandra versus Prabhavati, 1957, the court observed that if a spouse abandons the other spouse in a state of temporary passion, for example, anger or disgust, without intending permanently to cease cohabitation, it will not amount to desertion. Then there is constructive desertion. There may be cases where a spouse is forced by the conduct of the other to live separately or to stay away. In such a case, desertion would not be attributed to the spouse who lives separately or stays away. for the simple reason that the said situation has been brought about by the act of the spouse who has misconducted himself or herself. Imprisonment for 7 years. A spouse may file for divorce if the respondent spouse is subjected to a 7-year or more imprisonment decree for an offence laid down in the Indian Penal Code. On this ground, however, no decree for divorce shall be granted unless the respondent has already been imprisoned for at least 3 years out of the said period of 7 years or more prior to the petition being presented. Now, next fault ground is cruelty. The concept of cruelty is a changing one. The modern concept of cruelty includes both mental and physical cruelty. Acts of cruelty are behavioral signs stimulated by different factors in the lives of the spouses and their surroundings, and therefore each case has to be decided on the basis of its own set of facts. While physical cruelty is easy to determine, it is difficult to say what mental cruelty consists of. Perhaps mental cruelty is the lack of such conjugal kindness which inflicts pain of such a degree and duration that it adversely affects the health, mental or bodily, of the spouse on whom it is inflicted. In the famous English case, Russell versus Russell, 1897, the House of Lords observed that to constitute legal cruelty, there must be danger to life or injury to health, bodily or mental, or reasonable apprehension of it. In A. Jayachandra versus Anil Kaur, 2005, the Supreme Court of India observed that cruelty has been in relation to human behavior and conduct complained of and should be grave and weighty for arriving at the conclusion that the petitioner's spouse cannot be reasonably expected to live with the other spouse. Then, in Mayadevi versus Jagdish Prasad, 2007, again, the Supreme Court observed that the question of mental cruelty has to be considered in light of the norms of marital ties of a particular society to which the parties belong, their social values, status, and environment in which they live. What is mental suffering? It is pertinent to note that a guilty intention to cause cruelty on the part of the respondent spouse is not required to avail cruelty as a ground for divorce. Mental suffering caused to the other spouse, even in the absence of guilty intention, may constitute cruelty. In another case, Suman Kapoor versus Sudhir Kapoor, 2009, the Supreme Court observed that mens rea, that is, guilty intention, is not an essential element of cruelty. Relief cannot be denied on the ground that there has been no deliberate or willful cruel treatment. Dear fellows, next ground is unsoundness of mind. If either of the parties to the marriage is suffering from an incurable unsoundness of mind, and the unsoundness is of such a nature that the other party cannot be reasonably expected to live with him or her, the aggrieved spouse is entitled to file a petition for divorce on the ground of insanity. The expression mental disorder has been explained in the Act as mental illness, arrest, or incomplete development of mind, psychopathic disorder, or any other disorder or disability of mind, and includes schizophrenia. The expression psychopathic disorder means a persistent disorder or disability of the mind that results in abnormally aggressive or seriously irresponsible conduct on the part of the other party. It is immaterial that the mental disorder requires or is susceptible to medical treatment. In Santosh versus Nandan Singh, 1980, the court observed that mental disorders cannot be proved by the oral testimony of the relative of the parties. It requires being diagnosed by a medical expert. Further, such medical experts should be carefully scrutinized by the court. Now, next ground is venereal disease. Venereal diseases are those that are transmitted through sexual intercourse. If a party to a marriage is suffering from venereal disease in communicable form, the other party can file a petition for divorce. It is pertinent to note that after the amendment, now the duration of such a disease is no longer an essential requirement for filing a petition for divorce. Example of venereal disease is AIDS. The Honorable Supreme Court in Mr. X versus Hospital Z, 1998, observed that under Section 27 of the Special Marriage Act, the party to a marriage has been given the right to obtain divorce if the other party to whom he or she was married was suffering from a venereal disease, that is, in a communicable form. Therefore, it is a person's moral and legal duty to inform the woman with whom the marriage is proposed that he is or is not physically healthy and that he is or is suffering from a disease that is likely to be communicated to her. Next ground is leprosy. A petition for obtaining a decree of divorce could be presented by either party to the marriage on the ground that the other party has been suffering from a virulent and incurable form of leprosy. However, this ground has been repealed in 2019. Next ground is presumption of death. Amongst the rarely resorted grounds for divorce is that the respondent has not been heard of as being alive for a period of 7 years or more by those who would have naturally heard of it had the party been alive. My dear learners, now let's discuss the additional grounds of divorce available exclusively to the wife. Number 1 is rape, sodomy and bestiality. The wife may present a petition for a decree of divorce on the ground that the husband has, since the solemnization of marriage, been guilty of rape, sodomy or bestiality. Second ground is non-resumption of cohabitation after decree of maintenance. The wife may present a petition for a decree of divorce on the ground that in a suit under Section 18 of the Hindu Adoptions and Maintenance Act or in a proceeding under Section 125 of the CRPC or under the corresponding section 488 of the CRPC. A decree or order, as the case may be, has been passed against the husband awarding maintenance to the wife, notwithstanding that she was living apart, and that since the passing of such a decree or order, cohabitation between the parties has not been resumed for 1 year or upwards. Now, another very important provision is related to alternative relief in divorce proceedings. Section 27A provides that in any proceeding under this Act on a petition for dissolution of marriage by a decree of divorce, except insofar as the petition is founded on the ground that the respondent has not been heard of as being alive for a period of 7 years or more by those persons who would have naturally heard of the respondent if he had been alive. The court may pass a decree for judicial separation instead of divorce. Now let's learn about divorce by mutual consent. As the term implies, a divorce by mutual consent is founded on the parties' shared desire to sever their marriage amicably. The no-fault theory is another name for the mutual consent theory, which refers to the fact that neither party is seeking a divorce on the basis of the other's fault or guilt, but rather because they can no longer cohabitate as a married couple. A bare perusal of provisions of Section 28 of the Special Marriage Act makes it clear that certain conditions should be fulfilled in order to file a petition for divorce on mutual consent. These conditions are: firstly, both parties must file the petition for the dissolution of marriage by a decree of divorce with mutual consent. Such consent must be voluntary and free and shall not be obtained by the use of force, fraud, misrepresentation or undue influence. Then, from the day of the petition was presented, they must wait for a term of 6 months. During these 6 months, the parties have the option of withdrawing their petition. Parties shall make a motion before the court for passing a decree before the term of 18 months from the date of the presentation of the petition. The court shall, after hearing the parties and making due inquiries, pass a decree of divorce, thereby dissolving the marriage from the date of the decree. In the case of Sureshta Devi versus Om Prakash, 1991, the Supreme Court emphasized that living separately for a period of 1 year should be immediately preceding the presentation of the petition. It is necessary that immediately preceding the presentation of the petition, the parties have been living separately. The expression living separately connotes not living like a husband and wife. It has no reference to the place of living. The parties may live under the same roof by force of circumstances, and yet they may not be living as husband and wife. The parties may be living in different houses, yet they could live as husband and wife. What seems to be necessary is that they have no desire to perform marital obligations, and With that mental attitude, they have been living separately for a period of 1 year, immediately preceding the presentation of the petition. The second requirement, that they have not been able to live together, seems to indicate the concept of a broken marriage and that it would not be possible to reconcile them. The third requirement is that they have mutually agreed that the marriage should be dissolved. The Honorable Supreme Court held in Anil Kumar Jain versus Maya Jain 2009 that in exercising its extraordinary powers under Article 142 of the Constitution, the Supreme Court can grant relief to the parties without even waiting for the statutory period of 6 months. It is noteworthy to understand the objective of the remedy. The purpose was to enable a couple to adopt legitimate rather than fraudulent or collusive means to achieve legitimate goals. The concept of the consent theory is that since two persons can marry of their own free will, they can also be allowed to move out of their relationship of their own free will. Dear learners, next is divorce on the ground of irretrievable breakdown of marriage. An irretrievable breakdown of marriage implies that a marriage has broken down so badly that it is impossible to restore or retrieve it. According to the Merriam-Webster Law Dictionary, irretrievable breakdown of marriage means a broad ground for divorce that is predicated on the development of incompatibility between marriage partners and that is used in many states as the sole ground of no-fault divorce. It is also known as an irremediable breakdown of the marriage. The Tripura High Court, in the case of Shrimati Aparna De versus Shri Alok De 2020, described it as a marriage that is dead for all purposes and cannot be revived by the court's verdict if the parties are not willing. This is because marriage involves human sentiments and emotions, and if they are dried up, there is hardly any chance of their springing back to life on account of the artificial reunion created by the court's decree. Section 27 Clause 2 provides for divorce on the ground that the marriage has been irretrievably broken, that are, there is no resumption of cohabitation between the parties to the marriage for a period of 1 year or upwards after the passing of a decree for judicial separation. Second ground is there is no restitution of conjugal rights between the parties to the marriage for a period of 1 year or upwards after the passing of a decree for restitution of conjugal rights. My dear fellows, the present module may be concluded with the observation of the Law Commission of India, which was made in its 217th report, that the foundation of a sound marriage is tolerance, adjustment, and respecting one another. Tolerance to each other's fault to a certain bearable extent has to be inherent in every marriage. Petty quibbles and trifling differences should not be exaggerated and magnified to destroy what is said to have been made in heaven. The nature of marriage under the Special Marriage Act is contractual. Therefore, parties are entitled to end their marital relationship on the basis of the grounds available under the Act. Nothing can be gained by trying to keep the parties tied forever to a marriage that in fact has ceased to exist. Human life has a short span, and situations causing misery cannot be allowed to continue indefinitely. With this, we come to end of today's lecture. Thank you very much.